Good morning, everyone. My name is Eric Tonsul. I'm one of the shareholders in the POA section of our firm. Thank you for joining me this morning for a webinar on the ever-evolving deed restriction process. We're going to be talking about anything and everything deed restriction related, deed restriction enforcement related, I should say. And at the end, we will take questions. I'll take some questions as time permits. So if you have a question, feel free to add it in the chat. And again, I will address all the questions, as many as I can within the time permitted at the end of the webinar. Next slide, please, Kyle. So a little disclaimer. Disclaimer, the information presented today is based on the laws that exist as of September 19, 2023. Providing this information for educational purposes and not legal advice. If you have a specific legal advice question, please consult your association's attorney. All right, so today we're going to be talking about a couple of different things. First, we're going to be talking about dedicatory instruments, creating and enforcing governing documents, common violations, self-help, and statutory requirements as far as it relates to deed restriction enforcement. So first of all, with respect to dedicatory instruments govern the regulation of land use. Especially here in Texas, there's a common mentality that no one should tell another person what they can do on their property, but to preserve property values, you have to be able to regulate what some neighbors do on their property. So that's the inherent conflict. And so that's where restrictive covenants come into play to allow an association to administer a community plan to keep everything looking nice and pretty and keep those property values up. So we're going to talk a little bit more about those dedicatory instruments here next. Kyle, please. So Curley versus Walker is a Texas Supreme Court case from 1922. So deed restrictions go all the way back even further than that, but they've been a hot button topic now for over 100 years. So in Curley versus Walker, the Supreme Court held that an owner burdens his own land with restrictions because of the fact that a like burden will be imposed on his neighbor's lot, and this will be beneficial to both lots. So that's the whole genesis of deed restrictions and the enforcement of deed restrictions. Next slide, Kyle. So Property Code 209.024, dedicatory instruments is defined as each governing instrument covering the establishment, maintenance, and operation of residential subdivisions. So for example, your declaration, your guidelines, your bylaws, your policies, those kinds of things, those are all dedicatory instruments pursuant to 209 of the Property Code. So as far as the governance of these dedicatory instruments for associations, this is the hierarchy from top to bottom of the dedicatory instruments. So the first thing you have is a plat that a developer will prepare and record, which is the plat of the subdivision showing where the lots and common areas and things of that nature are located. And then you have the articles of incorporation or your certificate of formation. It's the same, means the same thing. It just changed. The name changed several years ago from articles to certificate of formation. Then you have your restrictions or your declaration, or however it's titled. Those are, as we all know, basically the Bible for your association as it relates to your restrictive covenants, assessments, lien language, that kind of thing. Then you have your bylaws. Your bylaws handle the corporate governance of your association. There's often a misnomer, or I don't know what you want to call it, but a lot of board members in particular refer to the deed restrictions or declaration as the bylaws. They are two separate documents. The bylaws handle, again, the corporate governance. For example, it talks about your meeting of the members, like your annual meeting, your board meetings, qualifications for directors, terms of directors, removal of directors, and voting, all that kind of good stuff. So again, just keep in mind, bylaws and deed restrictions are not the same thing. And then you have any architectural or builder guidelines, and any rules or regs, that kind of thing. So again, that's the hierarchy as far as if there's a conflict between any of the documents, then this is the hierarchy of which controls it. Obviously, the higher controls over the ones below it. Next slide. So then we also have state and federal law that applies to associations. This is not an all-inclusive list, but it gives you an idea. First of all, you have municipal ordinances. For example, if you're in the city of Houston, you have the City of Houston Code of Ordinances. Those are applicable as far as deed restrictions in the city of Houston. Then you have your state statutes. You have the Business Organizations Code. You have which is where the Nonprofit Corporation Act is located. You have the Property Code, which I live in daily, and most of the managers on this webinar who talk to me, we're always talking about the Property Code. And then the finance code is also applicable as it relates, for example, to amount of interest that can be charged by an association on delinquent assessment. Then you have federal statutes. You have the FDCPA. That's very important as it relates to Roberts, Markel, Weinberg, Beller, Haley is a third-party debt collector. Therefore, we are governed by the Federal Fair Debt Collection and Practices Act. So you guys may have noticed last year when we started doing the Reg F validation notice for our initial demand letters for collections, that is in response to a new law that went into effect. So anyway, governed by that. We also have the 1996 Telecommunications Act that relates to like satellite dishes and that kind of thing. We have the ADA, Americans with Disabilities Act, and the Fair Housing Act, or FHA. These are all, again, state and federal, and in this case, the municipal ordinances are local ordinances and statutes and law that are applicable to community associations. Next slide. So the declaration, that is where your use restrictions are located, your lien, your assessment language, your lien language, that kind of thing. It must be capable of amendment. It must change with the times. It must change as technology changes. For example, 40 years ago, email wasn't a thing. And now, people don't want to do snail mail if they don't have to. So, but a declaration may require, for example, a notice to be sent via snail mail. And so that's why, again, a declaration must be able to be changed to evolve with the times and technology. And as far as amending the declaration, 209.041H, again, this is for 209 associations. This is not condominiums. Requires at least 67% of the owners to amend a declaration unless a lesser percentage is set forth in the declaration itself. So as the declaration itself says 51% of the owners, then the 51% controls over the 67. Next slide, please, Kyle. So restrictive covenants, what are they? What do they do? The purpose is to protect and preserve property values. It's critical in importance without zoning. For example, Houston has no zoning. So that's why deed restrictions are of utmost importance if you're in the city limits, because without it, you really don't have much to go on. Before, where I used to live previously was in the Heights, and we had an association, but it really didn't exist, and there's no zoning. And my neighbor thought it'd be a great idea to have 8 pit bulls and use his front yard as a junkyard. It was really awesome. So that's where the critical importance of deed restrictions come into play, to give you the ability to maintain properties in a manner that's consistent with the community and to maintain the property values. Next slide, please, Scott. So enforcement by community associations, it's as permitted by the property code and as permitted by the restrictions. Again, if there's a contrary provision in the restrictions to the property code controls. However, there is some language in the property code that, for example, it says, unless otherwise set forth in the declaration, then this. So you got to look at that language because it's not a blanket scenario where the property code is always going to control. There are circumstances where it defers to the declaration or defers to the bylaws. So you need to make sure that you're at least be aware of the fact that there is a situation that the restrictions, if they're contrary to the property code, the restrictions may still, override the property code because of that language in the property code. Next slide, please, Kyle. So restrictive covenants in your declaration, they can either state an action that's permitted on a piece of property, state an action that's prohibited on a piece of property, and it also sets forth the persons and entities with the rights of enforcement. We'll talk about that a little bit later. But with regard to may state, let's go to the next slide. Actually, we get into this on the next slide, Kyle. So examples of restrictive covenants, they prohibit non-residential uses of property, no commercial use of the property, that kind of thing. Prohibit multifamily occupancy, require improvements to be maintained, and they require architectural control review, ACC stuff. I guess I'll talk about this now. This came up this morning with one of my clients, actually, and that is that I'll get into this at the end of the presentation, but there's potentially a special legislative session that is going to occur next month. And SB 1668 was one of the proposed bills that was vetoed by Governor Abbott, along with that mass vetoing that he did. One of those proposed bills, again, assuming the legislative session occurs, would affect the Architectural Control Committee and the composition of the Architectural Control Committee. So stay tuned on that. But so architectural review deals with the harmony of exterior design, colors in the area, and that kind of thing. So these are all things, examples of restrictive covenants that you will find in your deed restrictions. Next slide, Kyle. So 202.004B of the property code states as follows. I'm just going to read it. This is right. This is the statute verbatim. It says that a POA or other representative designated by an owner of real property may initiate, defend, or intervene in litigation or administrative proceeding affecting the enforcement of a restrictive covenant or the protection, preservation, or operation of the property covered by the dedicatory instrument. So this is the statutory authority that gives it the association the ability to enforce its restrictive covenants that are set forth in the deed restrictions in the declaration as it relates to that particular association. Next slide, please, Kyle. Now, Texas Property Code Section 5.06A, this is with respect to the recovery of attorney's fees. This says that the person or entity that brings an action to enforce restrictive covenants and prevails in that action is entitled to the recovery of reasonable attorney's fees. So this is an important statute for a couple of different reasons. One is not all causes of action allows a plaintiff or a party, I should say, to seek the recovery of their attorney's fees. For example, a property damage claim, typically you cannot recover your attorney's fees, even if you prevail in the lawsuit. So for example, somebody drives their car into the sign, the association's entrance sign, and you end up suing the person that ran into the sign. That's a property damage claim. You cannot recover your attorney's fees. You can cover your damages to the sign, but your fees are not recoverable. However, per 5.06, if you're filing if the association brings an action, as you see there, brings an action to enforce a restrictive covenant and prevails, then you're entitled to recover your attorney's fees. So that's why when we file a lawsuit against an owner for a deed restriction violation, that's why we seek an injunctive relief, the recovery of the attorney's fees, civil damages, typically in court costs. Now, however, let's say we sue an owner for failing to mow his grass, whatever it may be, and the owner actually prevails on the suit. The judge or jury says, nope, we're going to side with the homeowner, not the association. And that, in my hypothetical, the association filed a suit against the owner, not the other way around, and there's no counterclaim. So it's just a straight one-way traffic, filing a suit against the owner. Owner prevails. The owner is not entitled to recovery of his attorney's fees because, again, this is the person that brings the action and prevails. So in my hypothetical, the association brought the action and lost. So even if the owner prevails in that situation, the owner is not entitled to recover the attorney's fees. Now, if the owner if we file a suit against an owner, the owner files a counterclaim for, let's say, declaratory judgment action. A DEC action does allow the recovery of attorney's fees if the person bringing the action prevails, or actually either party prevails in the DEC action, whichever party prevailed. So there are circumstances where, if the association is involved in a lawsuit and the owner prevails, the owner may be entitled to seek the recovery of their attorney's fees if they prevail in the action. Next slide, Kyle. So, excuse me. Owners typically have the right to enforce the use restrictions on the property, meaning if you have a deed restriction violation and the association, for whatever reason, does not file suit against that particular owner for the violation, another owner in the association can file a suit themselves against that owner for being in violation of the use restrictions of the declaration. I keep saying use restrictions because this has nothing to do at all with the lien favor rights of the association. So if an owner fails to pay their assessments to the association, another owner cannot sue that owner for failing to pay the assessments and seek foreclosure of the association's assessment lien. Only the association can bring that type of lawsuit. So this is important because especially in the nuisance scenario, the neighbor-to-neighbor disputes. For example, I had this situation arise very recently, actually yesterday, where a owner's water line had busted and it was causing pooling of water in the neighbor's yard. And the neighbor whose yard had this water wanted the association to intervene and do something about it. Well, that is your classic neighbor-to-neighbor dispute. Having a busted water line is not a deed restriction violation. Now, if it's causing a nuisance to the neighboring owner, it's not affecting the community. It's only affecting that neighbor. And so that is your quintessential neighbor to neighbor dispute. And again, that, typically a declaration has nuisance annoyance language saying that you cannot do something that creates a nuisance or annoyance to another owner. So in this scenario, again, as I mentioned earlier, an owner has the ability to file an action against another owner for the use restrictions, which a nuisance annoyance would be a use restriction. So that gives you an idea of when that comes into play. Again, it's a case-by-case basis. It's not a one-size-fits-all. If an association is getting multiple complaints from multiple different people about an owner's nuisance annoyance, whatever it may be, then at that point, that probably would rise to the level of a community nuisance, and the association should probably get involved. Again, that's something that you're going to talk to your association counsel about to see, what your attorney's opinion is on the matter. Next slide, please, Kyle. So 202.04A of the property code, there's a presumption of reasonableness for an association. Again, forgive me for reading this verbatim. An exercise of discretionary authority by a property owners association or other representative designated by an owner of real property concerning a restrictive covenant is presumed reasonable unless the court determines by a preponderance of the evidence that the exercise of discretionary authority was arbitrary, capricious, or discriminatory. So two important things there. One, there's a presumption of reasonableness. If an association brings an action against an owner for a deed restriction violation, there's a presumption of reasonableness that the association is being reasonable and is acting in good faith to go after this owner for being in violation of the restrictions. However, if the court determines that the association was acting in an arbitrary, capricious, or discriminatory manner, that presumption of reasonableness can be rebutted or overridden. And we're going to talk about what that means on the next slide, please, Kyle. So arbitrary means failure to exercise honest judgment. Capricious is freakish, whimsical, fickle, changeable, unsteady, and arbitrary. And discriminatory is failure to treat all persons equally. So these are kind of the measuring sticks as far, or the factors that a court will take into consideration when when a suit is brought against an owner for a deed restriction violation. And these are very common buzzwords you'll see in an answer from an attorney on behalf of an owner when an association files a lawsuit. It's kind of the go-to saying that the association acted in an arbitrary, capricious, or discriminatory manner. Again, that's to bring up that 202.04 provision about rebutting the presumption of reasonableness if the court sees that the association acted in one of arbitrarily, capriciously, or discriminatorily. So that is why you see that quite a bit. And it's you got to be reasonable, guys. Some boards, that there may be a situation where you have a problem child in the neighborhood, and maybe the board's mentality is a little bit biased against this particular owner, and they may not be treating this owner like they are treating other owners. So you really got to be cognizant of that. Make sure that whenever you do the enforcement process for your associations, that you are acting in good faith on behalf of the association, and there isn't some kind of unsaid axe to grind. That's a death knell if you end up in a litigation setting. Next slide, please, Kyle. So for the enforcement of deed restrictions, there's a 4-year statute of limitations. That means that it's 4 years from when the violation existed, or the association should have known it existed. You have 4 years to enforce that restrictive covenant, meaning that 4 years means you have 4 years to get a lawsuit on file against the owner for being in violation of the deed restrictions. That's the discovery rule, is when you knew or should have known that the violation existed. That's what the discovery rule is. So by way of example, somebody paints their house purple with yellow polka dots 6 years ago. The board at that time didn't do anything about it. 6 years later, here we are, new board, it's turned over, and the board member's like, that house looks terrible. That's in violation of restrictions of the owner approved colors. We want to file a lawsuit against that owner. You can't. Well, you can, but you're probably going to get hit with a motion for sanctions for filing a frivolous lawsuit. I'm aware of one association that got hit with a frivolous lawsuit I forget the scenario. It wasn't one of mine, thank goodness. But long story short is that they proceeded against an owner for a violation that was in excess of 4 years. And the opposing counsel filed a motion to dismiss and sought sanctions. And the Exhibit A was a demand letter from like 8 years prior. And the court sided with the homeowner and sanctioned the association $20,000 for being in violation of the statute of limitations. So it's a very serious situation. So you need to be very careful with that. Now, the knew or should have known aspect of that, for example, let's say that somebody has an above ground pool, and above ground pools are prohibited by the deed restrictions, but they have a 6-7 foot tall fence. It's on a corner lot. You can't see it. You don't know it's there. And so, and so they've had it for, let's say, for 5 years. And then we have one of our lovely hurricanes that likes to come through here every now and again, and it knocks the fence down. And now all of a sudden we can see, hey, there's an above ground pool in this backyard. So that's the association knew or should have known. That's where that comes into play, because we had no way of knowing that the pool, above ground pool violation was there until the fence got knocked down by the hurricane. So that's when the clock starts, is when you should have known. When that fence got knocked down, you should have known that it was there. And now something like that is open and notorious, like the purple and yellow house I talked about earlier, you're going to have been deemed to know it existed when it was painted that color. So there's other defenses, latches, which is an equitable defense, a waiver. We're going to talk about waiver and abandonment in just a second. Next slide, please, Kyle. So the waiver defense basically says that you've acquiesced to such substantial violations within the restricted area as to amount to an abandonment of the covenant. So, for example, let's say that there is a provision in the declaration that says that yellow shingles are prohibited. But down your main drag of your subdivision, you have 50 homes that have yellow shingles on the roof. You know, a reasonable, ordinary, prudent person driving through your neighborhood is going to think that yellow shingles are permitted because of all the homes that have these yellow shingles. And so that's why, you know, the waiver defense is, you know, you have not enforced this restriction. There's so many examples of this violation that a reasonable, ordinary, prudent person would think that this is acceptable. So you could end up waiving that yellow shingle prohibition, or I should say enforcement of that yellow shingle prohibition, if you allow too many of the same violations to occur without any kind of enforcement. And again, just sending a demand letter is enough. You got to file your lawsuits. And also, if there's a change in conditions in the restricted area or surrounding area, no longer possible to secure a substantial degree of benefits to be realized through the covenants. Again, kind of the same thing as I said earlier, in that, you know, if you have an extreme amount of violations of your deed restrictions without enforcement, then that could be considered a change in circumstances. Next slide, Kyle. So in my yellow shingle hypothetical, just because if that's the only thing that an association is not enforcing, it does not negate the entire set of restrictions or declaration. It would just be that particular provision that would be potentially subject to waiver. Now, if you are not enforcing any of your restrictions, then there is a possibility that the entire set of restrictions could be deemed waived. So again, case by case basis, depends on the circumstances, but you can either have waiver one or a couple of restrictions, or you could have the whole set be deemed waived and not enforceable. So as I mentioned earlier, would a reasonable, ordinary, prudent person conclude that restrictions have been abandoned based on the number, nature, and severity of other existing violations? Last time I checked, it's been a little while, but there was, at least here in Houston, the appellate courts had held as far as the percentage that was required to potentially be deemed a waiver. One was 5% and the other one was 15%. Meaning, to make the math easy, let's say you have 100 homes. According to one appellate court, if you had 5 of the 100, which would be 5%, that were in violation and there's no enforcement, that may be deemed a waiver of that restriction. The other appellate court said 15 out of the 100 would be required in order to be considered a waiver of the restriction. Now, again, it's been quite a number of years since I've looked at that, so I probably need to look at that and see if that number's changed. I would think it's probably pretty close to about the same. But I guess the safe method here would be if you have 10%, I would say, and again, this is just my opinion. This is not based on the case law, but I would say if you have 10% of the homes or lots are in violation of something, you really want to get with your counsel on that, because there's a very real possibility that the enforcement of that restriction is potentially waived. Next slide, please, Kyle. So common violations of deed restrictions: lawn and landscaping maintenance, failure to mow your grass, trim your shrubs, dead shrubs, that kind of thing. Exterior maintenance, for example, mold or mildew on the siding. The house needs to be repainted. The roof, the roof is a mess, needs to be re-roofed, whatever the case may be. Also, no architectural approval, failure to submit for ACC or ARC approval prior to constructing an improvement or doing an improvement. Parking, for a lot of restrictions prohibit trailers and boats and RVs from being parked on a long-term basis at the property. Trash cans being set, stored in public view, and then again the nuisance annoyance. Like I mentioned earlier, those are just some examples of the common violations that we see that we get in our office from our clients, from owners that just are in violation. Next slide, Kyle. So self-help. What is self-help? It's a lot of you guys refer to it as force mows, but it's not necessarily only limited to mowing. Now, self-help, in order to do self-help, you have to have the authority to do it in your deed restrictions. If you do not have the authority in your deed restrictions, you cannot do it. And if you do it, there's potential that you're going to be, cited for trespass. So first and foremost, you need to review your declaration, your deed restrictions, see if you have the authority for self-help. Also, if you do, you need to see what the scope of that self-help is. Some declarations state you can use self-help for any violation of the declaration, meaning if it's lawn and landscaping, exterior maintenance, whatever. Some limit it only to mowing lawn and landscaping, mowing the grass only. So you got to look at that and see what it says as far as what your authority is. Also, if you do have self-help authority, normally it has a time period notice requirement that you have to send to the owner before you can enter the property and perform the work. So if you do have the self-help language, make sure you see what is that requirement. Typically, it's 10 days notice. That's not a one size fits all, but it's typically 10 days where you have to send a notice to the owner, give them 10 days to cure the violation. If not, then the notice says we're going to enter the property on this date between this time period to perform the work to bring your property into compliance with the deed restrictions. Now you see the bullet point says difference between can and should. Now let's assume your declaration gives you self-help authority and allows you to do anything that needs to bring the property into compliance with the declaration. Okay, so it gives you carte blanche to do whatever to bring the property into compliance. Let's say an owner has a big hole in the roof. It's a big eyesore. It's on the main drag. Everybody sees it. It looks terrible. You sent deed restriction demand letters, whatever, and the owner hasn't done anything about it. In my hypothetical, the declaration gives you the authority to enter the property and fix the roof. Now, again, can and should. Can you do it? Yes. Should you do it? Maybe, maybe not. It depends on what we're talking about. Because for the roof example, if the association hires a contractor to go in and repair the roof, and the repair isn't done properly or done well, and there's a big rain and there's leaking in the roof that causes damage to the interior contents of the home, the association can potentially be held liable because it was its contractor that performed the work to repair the roof. So you got to be careful with that. And also the cost of a roof repair, something could be very expensive. And so that's another factor to take into consideration. And the last thing is, you see that get off my property. Owners aren't going to be very happy about you entering their property to do something. Now, we typically say that the safe bet is if it's a front yard mowing, not a big deal. It's going to grow back. It's not a very intrusive remedy. Now, if it's in their backyard, or if it's like painting a house or something that's you can't unring that bell, owners can get very upset. And I've had one situation several years ago now where a contractor was brought in the front yard looked like a jungle, and a contractor was there to mow the grass and cut away some of the prune the trees and do all this work. and the lady literally chased the contractor with an axe. And so, if that happens, tell your contractor stop, load up, and leave. Last thing we need is something dangerous or safety issue to occur. Trying to do something like this. So that's why you really got to figure out what it is that's the issue. Do we have the authority to do it? And just because we can, should we? These are all factors you need to take into play and take into consideration when determining whether or not to use self-help. Next slide, please, Kyle. Okay, so 209.006 talks about uncurable and curable violations. Not the best terminology, but that's what the legislature decided it would be. So a uncurable violation is a violation that has occurred, but it is not a continuous action or a condition capable of being remedied by affirmative action. So in the property code, these are the examples that are actually cited in the property code. Shooting fireworks, you can't unring that bell. An act constituting a threat to health or safety. Somebody punches somebody at the pool. A noise violation that is not ongoing, like it may be a New Year's Eve party that gets really loud. Property damage, and holding a garage sale or other prohibited event. Those are examples of uncurable violations. Next slide, please, Kyle. And then you have your curable violations, excuse me. And these in the property code are parking violations, maintenance violations. Again, siding has mold or mildew that can be cured. Failure to construct improvements or modifications in accordance with approved plans, that can be fixed. And ongoing noise violations like a barking dog, that is an ongoing violation. Next slide, please, Kyle. There's also some statutory requirements for policies. So in the election code, it used to be in the property code, it moved now with regard to political signs and displays. You can regulate political signs and displays, but you have to have a policy on it. The property code does not automatically vest the association with the authority to regulate political signs and displays. You have to have a policy. And in the property code, the election code sets forth the parameters for the displaying of political signage with regards to a candidate or a ballot item. Religious displays, that is in the property code 202.018. Security measures, 202.023, 209 hearings, 209.007. So these are all, those three in particular were changed by the 2021 legislation. So, a lot of my clients have me draft the security measures policy, the bid solicitation policy, the religious display, and the 209 hearing policies. If you have not done that already and you're a 209 association, I would encourage you guys to talk to your attorney to see what policies you do have that have been recorded. Again, a policy is not enforceable unless it has been recorded in the county where the subdivision is located. But those are the policies, examples of policies with regard to deed restriction enforcement that are in the election code and the property code. Next slide, please, Kyle. All right, so what's new as far as deed restriction enforcement? This past legislative session that just occurred talks about a deed restriction enforcement and fine policy. So first and foremost, you have to have finding authority in your declaration or your bylaws in order to levy a fine. If you do not have finding authority in your governing documents, you cannot levy a fine. And therefore, there's no need to adopt an enforcement or fining policy. But if you do have finding authority and you do want to adopt and you do want to levy fines, now pursuant to the new law, which goes into effect on January 1st of 2024, you have to have a policy. And the policy will set forth the general categories of covenants for which the POA may assess fines. It includes a schedule of fines for each category and violation, and it talks about information on hearings described in 209.007. So if you are a fining community and you might want to, or not might, you should check with your attorney to make sure that if you already have a fining policy in place, that it complies with the new law that goes into effect on January the 1st. Each owner, and the requirement for this policy is that each owner must be provided a copy by posting on a publicly accessible POA website. That's one option. You do that, you're done. The keyword there is publicly accessible. So a portal that you have to log in is not a publicly accessible website. For example, if a title company wants to go to your website and obtain a copy of the policy. They can't because they don't have login credentials. So, but if it's just, association.com and, me, I could just log in and I could get your filing policy. You're done at that point. You just have to have it on on a publicly accessible website. If you have it on a website that's available by portal, then you have to annually send a copy of the policy to the owners via hand delivery, mail, or email. So keep that in mind. There's, depending upon how your association is set up, there are these requirements that now relate to a fining policy. Next slide, please, Kyle. Again, I mentioned this earlier. Right now, there's talk of being in a special legislative session next month. There's a high likelihood that Senate Bill 1668 will be placed on the legislative agenda. And so if the same version is passed again, it can be changed. There's always that potential that it can be changed. If it even goes to session, if it even goes before the House and Senate, it could be changed. But for what was introduced that got vetoed, it would require condominiums to have a publicly accessible website and post their management certificates with TREC, which is the same requirement that applies to 209 associations right now. It would amend 202.023 by better defining security measure requirements and also amend ACC eligibility requirements. Again, that's based on how the bill is right now. And so, again, it's not entirely guaranteed that this legislative session is going to occur next month. For all indications are that it is, and if it does, again, the SB 1668 is subject to revision or amendment. So we'll have to keep an eye on that. We'll keep you guys posted as that comes, down the line. Next slide, please, Kyle. So in conclusion, rules and restrictions vary from association to association. When you're enforcing restrictions, don't be arbitrary, don't be capricious, don't be discriminatory. Enforce the rules evenly against all owners in the community and be reasonable. I mean, that's, I know that goes without saying, but if the association is acting in a reasonable manner, it's very hard to rebut that presumption of reasonableness that we talked about in chapter 20204. So that is the conclusion of this presentation. I saw a bunch of chat messages come up during the presentation. Let me see if I can read this. All right. Not entitled to attorney fees, but judge can award attorney fees if they so choose. No, you have to file a cause of action that seeks the recovery of attorney fees. You can't recover what you don't plead or what you don't ask for. And so if you can't ask for attorney fees, the judge isn't going to award attorney fees. That'd be grounds for appeal. Our rules and regs differ from restrictive covenants. As things evolve in a POA, situations arise where having a rule would be easier to implement than adding it to the CCRs. How does a POA handle actions by an owner that are not in the CCRs but are detrimental to property values of the community? Would that come under rules and regs being created? So a rule and reg, first of all, you have to have the authority to adopt rules and regs or guidelines. If you're in Harris or Montgomery County, you can under chapter 204 of the property code. If not, then you have to have rulemaking authority in your declaration. Now, you cannot create a rule or reg that's going to contradict or create a restrictive covenant that is not in your declaration. That's tantamount to doing an end around and not, amending your declaration the proper way in order to implement something that you have. So again, that's something you need to get with your attorney about depending upon what the situation is. For example, some declarations say, here's the rules with regard to parking. The board shall be authorized to adopt any additional rules and regulations with regard to parking. There, you're good. But if your declaration says parking shall be allowed at all times on a lot, whatever, I'm making something up, and you adopt a policy or a rule and reg that says parking shall only be allowed between these times on a lot. Well, now you're drafting something that's contradictory to the declaration. That is not an enforceable provision because it goes against the declaration. The declaration is superior in the hierarchy as opposed to a rule and reg. How to update restrictions. If your subdivision has 44 separate sets of restrictions requiring a major I assume that's a majority of property owners in the section to amend the restrictions in part or in whole. Yeah, if you have typically, again, depends on the language and the restrictions that we're talking about. But if you have 40, let's say you have 44 sections and 44 sets of restrictions, typically the way to amend is either 67%, unless there's a lesser percentage in the restrictions, on a section by section basis, which means you may have some that are approved in one section and in another section they're not approved. It can be a nightmare. That's like herding cats. So again, go with your attorney on that. Discriminatory manner. Is this what is meant by selective enforcement? Can you briefly discuss selective enforcement? Selective enforcement is not treating everybody the same. That's discrimination. Again, it's not race discrimination. It's not treating everybody the same. So, one homeowner has, let's just say, an outbuilding and outbuildings are not permitted in the subdivision, for my hypothetical. So you got an owner that has an outbuilding and a board member that has an outbuilding, and you enforce a restriction against the non-board member, but not against the board member. That's selective enforcement. That's discrimination. You're not treating everybody the same. In that hypothetical, the board member and the owner should be getting deed restriction enforcement letters for being in violation of the restrictions. Please address how frequently deed restrictions can be enforced for repetitive, constant violation, common street usage. They can be enforced as frequently as you want, but if it's the same issue over and over again, and rather than spinning your wheels with letter after letter after letter, I would suggest that you consider having that matter turned over to your attorney and have the attorney send the deed restriction enforcement demand letters and ultimately filing a lawsuit seeking injunctive relief if the owner continues to be in violation, rather than just sending letter after letter, because you might run into the statute of limitations issue I referenced earlier. Does the statute of limitations apply to curable violations which have been ignored for 6, 7, 8 years? Can you explain the concept of latches? So yes, it does apply to cure. Again, it is what it is. So let's say a curable violation, for example, is like maintenance of the house. You have mold and mildew on the exterior of the property, and it's existed for 6, 7, 8 years. Owner hasn't rectified it. Now, 8 years later, the association tries to file a suit for that mold mildew on the exterior. It's statute of limitations. You're barred. You file that lawsuit, you're subject to sanctions. Apparently, there's a law which goes into effect January 1. All right, I already talked about that. I have a question about discovery. If a management company takes over communities management and sees an item out of compliance, is that the discovery trigger, or is it incumbent upon the board and therefore it should have been known? It should have been known. It doesn't matter that there's a change in management. It's when the association, not the management company, the association knew or should have known that the violation existed. Discovery. If the CCRs clearly state that running a business out of a home is forbidden, but no one knew, are the people running the business off the hook after 4 years? If they clandestinely have been running a business, is it really the business of the board to go around annually to ask owners if they're running a business? No. And that brings up a kind of a couple of different issues. One, if whatever's being done at the property isn't even noticeable, you don't even know it's happening, how really invasive is that to the community? For example, I work from home a couple days a week. You drive by my house, nobody's going to know that I'm in here being a lawyer. So it's really kind of more the overt actions. It's, for example, like, let's say it's a landscaping business being run out of the home. And so all the employees, workers park all their cars in front of the house, and they got, bags of mulch that are stored in their driveway and that kind of thing. It's really the more obvious, thing. So no, there's no obligation to annually ask neighbors or owners rather, if they are running a business out of their home. And quite frankly, they're probably not going to tell you that they are, if they are. All right, I answered that. Can a waiver of the restriction apply to an incurable violation such as discharging fireworks? Yes, it can. So with discharge, like for example, an uncurable violation, there's basically two consequences of that. One is potentially, if you have the authority in your declaration prohibiting use of common areas, such as the pool, for example. Again, if you have the authority in your declaration, the other is fines, assuming you have fining authority. But if you constantly, there's fireworks going all the time, you never enforce it. There's a potential that if a lawsuit were to be filed, that a judge or jury could determine that restriction has been waived. Is there something that needs to be written for waivers? No, again, that's usually a judicial determination by a court. How can an HOA reasonably enforce multifamily dwelling violations? 6 trucks parked in front of a property. These folks are obviously adults, not teenage children, and probably not related. How can an HOA get proof that is a multifamily dwelling? Shelley, that's a very hard one to enforce. Really, there's a couple of different things. A lot of it's going to come down to how much are the neighbors of this property willing to be witnesses on behalf of the association in the event a suit is filed. And most neighbors don't want to rat out their other neighbors. So that's difficult. If there's multiple cars, you can run the license plates to see who the registered owner of the vehicles are. That might give you some proof. But that is just, in a nutshell, proving the multifamily occupancy of a dwelling is very difficult. It can be very difficult. Let me clarify that. So again, if you do have an issue like that, that's something you need to get with your attorney and see, what evidence is available to the association to enforce that restriction. Now, we'll caution and warn you guys. A lot of neighbors are, contact the management company or the board, and they're hopping mad about their neighbor and, oh yes, I'll testify, I'll take a deposition, whatever it takes. This is ridiculous. I'm not going to put up with this anymore. And then when it comes down to brass tacks and it requires them to take a day off from work to go to a deposition or take a day off from work to go to a hearing, well, what do you mean I have to, take a deposition all day? I'm going to have to take a vacation day from work. I'm not going to get paid. No, I'm not going to do it. That has happened multiple times over my career. So just a word of warning that even some of that is really loud and making all kinds of noise about making the association do something, if they aren't willing to, actually do something about the situation themselves, as far as like being a witness or testifying at a hearing or in a deposition, then you might want to reevaluate whether or not you have enough proof or evidence without that neighbor's testimony to bring that action. For self-help, does the notice have to be certified and can it be billed back to the owner? It depends on what your declaration says. I've never seen a notice that can be billed back to the owner. The only way you can do that is if your declaration specifically says so. As far as certified, again, it depends on what your declaration says. If it says certified, then yes, it must be sent certified. If it doesn't, then no, it does not. Does the requirement for self-help language apply to both HOAs and condos? Yes, it does. Condos are a little bit different. The property code, chapter 82 of the property code actually gives you, like for example, if there's a situation in a unit that requires association immediate entry to fix something that's causing a damage to common elements or to another unit, then you have authority there. So again, it all depends on what your declaration says in conjunction with condos in conjunction with what chapter 82 of the property code says. Is charging an administrative fee different than a fine? Yes, it is. I guess it depends on what you're talking. It's kind of a loaded question. If it's purely an administrative fee, then yes. If you're calling it an administrative fee, but it's really a fine, then no. If there is no fine policy and the association does not have it written into the declaration to do so, how do they establish fines? They would either have to amend their declaration, which again requires approval of the owners, or amend their bylaws to include finding authority in their bylaws. Now, the issue with finding authority in your bylaws is that you cannot make those fines a secured charge. What does that mean? That means a charge that's secured by the association's assessment link. There's more teeth to secured charges as far as the collection of those secured charges. An unsecured charge is just that. It's not secured by the lien. So assuming you amend your bylaws to allow finding authority, and then you adopt a finding policy, and you levy $1,000 against an owner for in fines for violating your declaration. Owner doesn't pay him. If you file a lawsuit, you cannot file a suit seeking the collection or seeking foreclosure of those fines. Now, there is a provision in the property because you can't solely foreclose if the amount owed is purely based on fines or attorney's fees related to the collection of fines. So there is that qualification. But with unsecured fines, again, fines that are created in the bylaws, typically the bylaws can be amended only by the board. Again, it depends. It's not a one size fits all. But if you amend your bylaws to have finding authority, and that finding authority, those fines are not secured, and if an owner fails to pay those fines, You can only file a suit to get a judgment for those fines. But again, you can't foreclose. You can't do anything. It's a paper judgment. So there's not a lot of teeth in that judgment. Now, it may be that having the ability to levy fines is enough of a deterrent for owners to not do whatever it is to violate the declaration. But again, to answer your question, that's how you do it. Either amend your declaration or amend your bylaws. If self-help language is present, does a recent state law change require 30 days notice prior to enforcement? No. So self-help is not a 209 letter. This is different. A 209 letter, because a self-help, you send the notice and they don't comply, and then you go in and correct the violation, you're done. Your 209.06 is the statute that sets forth the requirements before a matter can be turned over to an attorney for deed restriction enforcement action and seek the recovery of your attorney's fees. In a self-help scenario, you're not seeking the recovery of attorney's fees. You're sending a notice, and if they don't comply, you're fixing it and you're done at that point. So no, the 30-day notice is not applied to the self-help notice unless your declaration specifically says you have to give them 30-day notice. Then in that case, yes. For the may not enforce laws that apply override to CCRs that can't be easily changed, what is the best process to note, document the provisions of CCRs that Texas law has overridden? It's just reading 209. Chapter 209 of the property code. You can get it online for free. I'm sorry, I got something in my throat. Give me 1 second. Sorry about that. So reading 209, seeing what it says as far as those provisions, and then making note of it. If a portal is not a public website, then why would anyone pay for a resale certificate if you could get all the info for free? Does this include 209 and 208? They have, because not all the information is available on a portal. A resale certificate is not just the governing documents. There's other information that they need to obtain. And so, so just having information documents only on a publicly accessible website that's not enough. My board fails to enforce deed restrictions on basketball goals. What is the recourse? Is the board able to choose what to enforce? No, again, that's selective enforcement. You're choosing which restrictions to enforce, which ones not to enforce. It's the obligation on the board acting on behalf of the association is to enforce all of the restrictions. You're not supposed to pick and choose what restrictions you want to enforce. So if an association fails to enforce a restriction, there's a couple different scenarios. One, potential waiver, which is already talked about, or two, an owner could potentially sue the association for failing to meet its duty to enforce the restrictive covenants. So that's not a good thing. My board wants to install speed bumps. Speed bumps are not included in the covenants. Does the construction require an owner vote? That's definitely a question for your attorney. That's a very specific question. How should we handle lawn shrubs that have died due to heat and watering restrictions? Yeah, in situations like that, or like Hurricane Harvey, for example, where force majeure, act of God has occurred beyond the owner's control, any owner's control. I would definitely recommend that the board exercise some leniency in the enforcement. I'm not saying abandon enforcement altogether, but you may want to abate the deed restriction enforcement process for a certain period of time, based on, in this case, this hypothetical weather conditions, because there's not a lot that can be done. We've had here in Houston, we've had months of 108-degree heat. Nothing can really survive. And then with the water conservation issues that have been set forth, it wouldn't really, well, that's not really, it wouldn't be reasonable to, file, a suit against somebody for dead shrubs when, the situations we have. So again, exercise being reasonable and being understanding of, situations like this. Thank you for the informative session. You're welcome. Follow up regarding clandestine business. It is VRBO. We are a gay community, and some feel this business is a threat to our security by giving out gay codes. So there's a couple of Supreme Court cases with regard to short-term rentals, and you have to have very specific language in your declaration if you can even enforce short-term rentals. There's a possibility of if you're in Montgomery or Harris County, Under 204 of the property code, you could adopt a policy prohibiting short-term rentals. It is subject to challenge. Let me be clear on that. It would be much more ironclad if the short-term rental prohibition was in your declaration. So again, I encourage you to talk to your attorney about your options with regard to that. And as far as VRBO, a lot of times you can just go online and see if the property is advertised for rental, things along those lines. So that's very good evidence of the fact that the property is being used for short-term rentals. But again, you have to have very specific language with regard to short-term rentals. If it's not there, you can't read. The Supreme Court says you can't read into your restrictions what you want it to say. It has to say it in your restrictions. So that's why I say get with your attorney, see what your enforcement options are. Is a short-term lease that violates that violates a covenant against Airbnb is a curable or not curable that requires a hearing for a fine. All fines require a hearing, regardless if they're curable or not curable. You have to send a 209 letter giving them opportunity to request a hearing with the board. If it's a one and done, then that's uncurable because they're done. Now, if they are consistently advertising the property for short-term rental, then that would be a curable violation. I don't believe you can look up license plate any longer. I know you can't on public data. Melissa, you may know better than I. That's not something that we do at our firm. That's usually a management company or an association thing. So I'll defer to you on that one. HOAs can now ask for copies of a lease, but I assume it's not required that the landlord turn it over. Again, if you have a leasing and occupancy policy or something along those lines, or it could be in your declaration that requires an owner to turn over a lease, they can. Again, what the statute does not allow is for the board to approve or disapprove a tenant. You can't do that. You can only request copies of the lease and the other information in the property code. Would a garage apartment being listed for rent be enough to prove multifamily? Well, typically in the declaration, not all the time, but typically it says that only the entire lot can be rented out. You can't rent out rooms or portions of a lot. So I would say look there first, because that would be a stronger argument rather than a multifamily. I would say look for that, because most declarations have language to that effect. That you have to lease out the entire property. In other words, I can't rent out a room in my house. If I'm going to rent out my house, I have to rent out the whole house, the whole lot. I can't be here. I have to leave for a meeting. Can the PowerPoint be emailed to me, please? Yeah, we can take care of that. How should an association handle an RV that's been parked in the driveway for an extended period of time? The association has been sending violations and fines, but the homeowner just pays the fines and the RV remains. I would file a lawsuit. Again, if an owner doesn't care about fines, file a lawsuit seeking a permanent injunction with compliance with your deed restrictions. How do we get the city to investigate rentals on VRBOs, Airbnbs, since the owners are not paying the hotel motel occupancy tax? That's something that you should contact your city and find that out. If the bylaws are being changed to amend restrictions, is there a requirement for the percentage of ownership approval if the board does not have the authority to amend? Okay. Well, again, there's no restrictions in bylaws. That's what I mentioned at the beginning of the webinar. You have your bylaws and you have your deed restrictions. So you're talking about amending the bylaws. The bylaws should have an amendment provision at the end of the bylaws that says what's required. A lot of them say must be required by a majority of the vote of the owners at a meeting called for that purpose. Some say may be amended by a majority of the board of directors. It all depends on what's going on. There's also section 22.102 of the Business Organizations Code that talks about amendment of bylaws. In some situations, even though you may have language in the bylaws that say it has to be amended by the members, it can be amended unilaterally by the board. Again, get with your attorney on that. Just know that's out there, but again, that's something that requires specific legal advice. All right, guys, I think I got time for one more. How do we enforce RV trailer if there is no item on DCCRs? Could we send a violation with a bylaws clause such as board shall act on instances on behalf of the association, regulate the maintenance and appearance of the lot? If you don't have a specific provision in a declaration, that's most likely a losing battle. I would encourage you guys to consider trying to amend your bylaws to prohibit that situation. Should the owners running a VRBO be required to show some sort of liability insurance to the POA in the event their renters are injured on POA property? That's kind of difficult because, again, now you're treating them differently than other owners. What about other owners that are renting their property, long-term rentals? Are you requiring those tenants to provide, or those owners to provide liability insurance to the POA? If you're not, then arguably you're not treating these owners the same. You have different requirements. So again, get with your attorney on that. Last one, you say that bylaws can amend to include fines, but CCRs do not. Okay, just so I'm clear, just so we're clear, I should say, fines in your declaration, ironclad, that's the way to go. If you don't have it there, you can put finding authority in your bylaws, but they're not going to be secured by the association's assessment lien. So yes, you can amend your bylaws to include finding authority, even if that finding authority is not in your declaration. All right, guys, it is 12:31. I'm going to let you guys go. I am starving. And so I appreciate you guys joining me. I got a lot of thank yous. You're welcome. Thank you. I hope this is informative. And last but not least, if you found this helpful or what our firm does, let us know how we're doing. Please leave us a Google review if you take a few minutes to do that. We always love to hear feedback on, how we're performing for our clients and the information and education we provide. So, if you could, there's a link in the chat. If you could just take a few minutes, we'd really appreciate it. So again, thank you so much. I appreciate your time. You guys have a great rest of your week. We'll see you next time. Bye-bye.